Companies Act, Section 216, Investigation of Ownership of a Company. Section 216 of the Companies Act, 2013 empowers the central government to investigate the true ownership and control structure of a company, particularly when there is a suspicion that the real individuals behind its operations or financial interests are not transparent. This section provides for an inquiry into those who hold or have held beneficial interest, financial stakes, or material influence in the company, regardless of their formal position or legal title. This provision ensures corporate transparency, helps prevent fraudulent activities, and supports regulatory scrutiny where ownership or control is obscured or concealed. 1. Powers of the central government to investigate ownership. Subsection 1 states that if, at any point, it appears to the central government that there exists sufficient reason to do so, it may initiate an investigation into the affairs of a company. The government can appoint one or more inspectors to investigate and report specifically on matters concerning the company's ownership and membership, with the intention of identifying the actual or beneficial individuals involved in or influencing the company. The purpose of such an investigation is to determine the true persons who a. are or have been financially interested in the success or failure of the company, whether such success or failure is actual or merely apparent. b. are or have been in a position to control or materially influence the policy decisions of the company. c. have or had beneficial interest in the shares of the company or are or were beneficial owners or significant beneficial owners. This subsection emphasizes the need to look beyond the formal ownership records and focus on the real beneficiaries behind the scenes, including those whose names may not appear in the official register of members. 2. Mandatory appointment of inspector on tribunal's direction. Subsection 2 mandates that the central government shall appoint one or more inspectors under subsection 1 if the tribunal, example, National Company Law Tribunal, during the course of any legal proceeding, is of the opinion that there is a need to investigate the membership of the company, and any other related matters falling under the scope described in subsection 1. This makes it obligatory for the central government to act when such an order is issued by the tribunal, ensuring that judicial observations regarding suspected hidden ownership or control are acted upon through formal investigation. 3. Scope of investigation can be defined or limited. According to subsection 3, when appointing an inspector under this section, the central government has the discretion to define the scope of the investigation. This scope can include the specific matters to be investigated, the time period that the investigation should cover, a particular focus on specific shares or debentures, or other relevant instruments of ownership or financial interest. This provision ensures that the investigation is purposeful and tailored, avoiding unnecessary inquiries and allowing the government to focus resources efficiently on matters of concern. 4. Inspectors' authority to investigate informal arrangements. Subsection 4 expands the authority of inspectors by stating that, subject to the terms of their appointment, inspectors may examine any circumstances indicating the existence of arrangements or understandings which, while not legally binding, are or were observed in practice and which are relevant to the investigation. This means that the inspector can look into informal relationships, verbal agreements, or customary practices that may not be legally documented but are effectively influencing ownership or control of the company. This power is particularly useful in cases involving proxy ownership, nominee arrangements, layered ownership structures, or front companies, where actual control or benefit is masked by seemingly disconnected entities or persons. Purpose and implications of Section 216. A. Transparency. The section ensures that the real individuals behind a company, whether they are shareholders, controllers, or beneficiaries, can be uncovered and held accountable. B. Regulatory oversight. It helps regulatory authorities maintain oversight over companies that may otherwise use complex structures to hide beneficial ownership. C. Prevention of fraud. By exposing concealed interests or influence, Section 216 serves as a tool against fraudulent practices, money laundering, and corporate misconduct. D. Tribunal-driven accountability. When the tribunal detects irregularities during any legal proceedings, it can trigger a mandatory investigation, compelling the government to act. For more details, contact us.